also going to be sending a packet of information as a follow-up with some really great links to reference material that Harry's going to talk about here today. So look for that link as a follow-up. Give us a couple of days as we edit the video and get it out with that link. And we'll take it from there. Harry?
All right. Well, thank you, and good morning, everybody, and welcome to our third edition of Wealth Protector TV. Today's a very interesting concept that we're going to talk about. We're going to talk a little bit about exit planning for our businesses. You know, when I hear that, and, you know, I've been doing what we would call exit planning for 40 years. When you hear that, you begin to think, you know, what is it? And we think about, you know, our businesses that we have and the businesses that we run, the businesses that we own, whether we own 100% of them, 25% of them, 50% of them. There's an adage, and I think we start today with that adage. And the adage is every one of us is going to exit our business. Everyone, 100%. It's nothing, you know, it's just absolutely amazing that we will do that. And we will do that voluntarily, or we will do that involuntarily. But every single one of us with us today and tomorrow we will all exit our businesses. Now, how we go about doing that and the ways to maximize that are very, very important to our discussion today. I think without this foundation, the whole concept of exit planning, which I see bandied around so much, it's almost like, you know, it's on the back seat of a bus bench, makes no sense. But we have to understand that exit planning is the intersection of many disciplines. There are tax-related issues, there are investment-related issues, there are asset protection-related issues, estate planning issues, psychological issues, financial planning issues. All of those issues are intersecting there. Family relationship issues, depending on whether or not children are in the business, children are not in the business, whether or not brothers and sisters are in business, parents are in the businesses. You know, you look at all of the dynamics, and again, this becomes absolutely so expansive, it's amazing. But we all will make an exit. And one of the things that I think are factors that are very important when I speak with clients about exit planning is sometimes we don't have a great picture as to the value of our business. You know, I probably look at 10 to 15 new cases per week of data on business owners across America. And when we get to the business or businesses and their structures, we try to drill down a little bit to get some valuation of what it's worth. It's all over the place. And some people undervalue their businesses. Some people overvalue their business. Some people have no concept of what the business is worth. And it also, when we talk about exit planning, how we exit has a lot to do about how much it's worth. And I'm going to talk to you about that. So I think that's very important. And I think another important concept that we fail to understand is before one begins an exit plan, one really needs to do a financial plan. Why? Because we need to know if we were able to sell our business or exit our business or transition our business, the amount of net value after taxation that we have, is that enough to support our lifestyle, our future, and our children? And I find it very, very challenging to, without knowing the risks that we face, the long-term care risks that we face, the tax issues that we face, the estate issues that we face, all of the you know, the retirement plans that we've done in the past, how health insurance, unless we have a really good picture of goals and objectives looking forward for the financial, we may have a very successful exit voluntarily, but still struggle because we were unable to achieve revenue. So let me explain that. So we have sweat equity when we're working. I'm working now, you're working, and we get income. And that income adjusts for inflation, and we have an income. And that income usually is much greater than 0.5% to 1% of the value of the business. Someone's got a $10 million business, they're not getting $1,000 revenue from working. They're getting sometimes, five, six, seven, $800,000 a year, $500,000 a year, and that's fine. But if I turn, even without taxes, if I turn that $10 million into investment income, if I'm getting the prevailing rate safely today, maybe my income is going to drop from 700,000 to 250,000. Now what do I do? I might not even be able to cover the insurance premiums that we face in the future. So I think it's really important that we have financial planning that has goals, objectives, and targets. So we have to have that. So we have the goals, objectives, and targets, and now we begin to look at our inevitable exit from the business. So if there are two kinds, there's voluntary and involuntary. We'll start with the voluntary exit from the business, and we'll explore that on the front half of our conversation today. And then we'll talk about the involuntary exit from our business on the other side. So on the voluntary exit in our businesses, we've decided for, 20 different reasons that we want to leave the business, or we have an offer for the purchase of the business. But more often than not, the exit is that the builder of the business, the owner of the business, has just said it's enough. It's time to move on to the next phase. They've done some financial planning. They know the number that they have to have net after taxes and believe that they can achieve that. So our first transition is there are two types in sales. When I ask most owners who they would like to, if a business is not being inherited, who they'd like to sell to. We'll talk about the inheritance portion in a moment. And the answer is many times is to the key management of the business and or family members that are working in the business. It's just almost universally 75% of the people that I speak to, including myself, that's where we would like our business to transition to and move on for the future. But it's foisted with some problems because inherently, those people, the family members or key management, although they may be the best people for the business, they themselves are missing something that we all need. It's called capital. They don't have any money. So they don't have the money to purchase the business. And so inherently, if we're going to transition our business that way, we become the bank. And so we have to, because no one's going to lend them any money. They don't have any money. So if we want to sell the business to them, we have to basically hold the paper. And you see this happening all the time. We have an installment contract. They take over the business. We get paid, maybe. And you know what? One of the reasons we left the business or we're thinking of transitioning and exiting the business is because, we wake up at night, we've had enough of it, there's so many things on our mind, so many variables, so many problems, so many issues, so many lawsuits, blah, 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 blah. It's time that we want to get out. But, when we do and we're the bank, all that's happened is we've transitioned the management or the control of the business to our key management people who have bought us out and or to our children who are in the business who bought us out. We're the bank. We're getting very, very little down payment, and it's usually stretched out over a number of years on an installment sale and secured by the business. And you know what? We still wake up in the middle of the night because we've never walked away, because the difference is we're no longer in control. Others are in control, but our entire potential financial future is dependent upon their ability to make those payments to us in exit planning. Wow, that's a kind of an awful position. So it's an interesting statistic. Take a look at this one. The interesting statistic is that although 70 to 75% of people that are selling their business in a voluntary exit wanted to go to family that's in the business, helping them run the business now, and or key management, 85% of them sell to a third party on the outside. So that transition never really happens. So forget all the books. This is what actually happens, because at the end of the day, they want to be able to sleep at night. They want to have some money up front. They want to be able to deal with the taxes effectively. They know the number they have to hit. Somebody gives them a LOI and ultimately a definitive contract, and away we go. And so that's what happens. And now we're dealing with sometimes disgruntled family members or the mass exodus of management, which leads to further problems for the people that bought out the business. So it's an interesting in looking at that and what can we do about that. And we're going to talk about that today somewhat. Now, for those of us that have decided to make an exit by selling our business to a third party. So if we don't have family members or family members that are interested in buying, can't buy, or management that can or can't buy, we decide to voluntarily sell our business to an outside third party. We're getting a number. We're going to get into what is beyond today's concept, whether it's an asset sale, whether or not it's going to be an equity sale, whether or not we have continued liability, indemnities, earnouts, and all of the issues that are associated with that. Here are some things that are interesting to note, and a very important, interesting to note when we're selling to an outside third party. So outside third party has their own investment bankers, or we placed our business with an investment banker. We might even have a private auction that goes on in selling our business. And so the price that we get for the business is interesting. And here is a real good tip to each and every one of you who are considering to sell that business to an outside third party. And that is to make sure that the business looks legally pristine. What do I mean by that? If we were selling a car, selling a house, it's new rugs, new paint, staged, it has to look good. Believe me, when your business has all its leases up to date, all its contracts perfectly done, all of its statutory minutes and organizational things done properly, when we have a business that looks legally pristine, all right, no lawsuits, no issues, no problems, you will get literally 10% more for that business than if that business does not look good. If things are disheveled and not right, the buyer is going to take that into consideration in lowering the purchase price as a premium risk in getting with you. So it's very important that we do that. It's also very important how the exit is structured from a tax perspective. But we're going to leave that for another day and talking about mergers and acquisitions. But let me talk to you a little bit about a voluntary exit to those of us that want to sell or need to sell our business to management and or to family members who don't have any money. So many businesses, and we'll talk about this as an exemplar, are S corporations or LLCs, taxed as S corporations. And in selling our business to these people where we are the bankers and carrying the paper, there are a couple of tax factors that need to come into play. Let me share a tool and a technique with you that we have found to be very, very helpful. So understand that if I'm an S corporation and I am selling my stock to top management, here's what has to happen. So top management buys out the business. It's an S corporation. They will earn their money. They will pay all their expenses. And then from after they've paid both state and federal taxes on the money, then they'll pay me money. All right. And then I will pay state and federal capital gains taxes on the principal and ordinary income taxes on the interest. Okay, got it. And that's a little challenging because we're running through all these tax brackets and trying to purchase the business. Let me give you a suggestion that one of the things that you could do. So first off, how about getting an appraised value of the business at its lowest, absolute lowest defensible rate? I'm not saying below the defensible rate, it's lowest defensible rate. And that's the price that we sell the stock at. All right. That's the one that, they're going to make an installment sale. They're going to make the payments to us, and they're paying it after taxes. Then if we have a little bit of runway, in addition, the management team or the family members, they don't want me to compete with them, to open up a store across the street and compete with them. So we negotiate and enter into an appropriate and proper non-compete agreement. So I'm going to have three sources of business revenue. One source of revenue, the actual contract and the installment sale, which is all done with after-tax dollars and I'm paying taxes on. And then we can evaluate and give me a non-compete agreement, which will be deductible to the business, making it easier for the next generation to pay me. And I will recognize it as ordinary income on the other side. But it's a nice sweet spot to be able to mitigate some of the taxation. And then third, there's nothing wrong with them offering me a number of years as a consultant to the company. After all, I did run the company for numbers of years, and pay me a consulting fee, which again is deductible by the new owners and taxable as ordinary income to me. But the combination of direct sale, covenants not to compete, paid for independently, and consulting agreements, when worked properly, can make it easier from a tax perspective for the new buyers in order to pay me. And I think that is a very important component in trying to get everything structured properly for tax purposes. The other thing too depends on how much runway and how much time we have and the character of the business. Now, for most exits, really we should have at least a 3 to 5 year runway in order to plan for that exit, to get the firm to look legally pristine, to make sure we've done all of our financial planning, to make sure we have the management buyout group or our employee group and or appropriate and opportune times for investment bankers to help us with the exit. And the other thing they could do, depending if I am the old guy in a company and we have a bunch of young people, is establish a very, very large defined benefit pension plan for me that the business can fund, that can also help, not having to pay me as much as possible in the contract for the business. So another way in which to get income to me, which is a deductible expense to the business. Now, we do understand that there are some times that businesses just fail. And so we're going to cover that in our involuntary exits. So I think it's very important to have some runway. It's usually about 5 years. We plan, we do the financial planning, we do the tax planning, do everything that's involved, decide who's going to be the buyer, trying to find a way, if we have our key people that we want to go to have that go to them. Now, in the key people scenario, we have a very, very interesting structure that if we establish some type of golden handcuff plan for the key people, and we fund it such as a phantom stock plan, phantom membership appreciation plan, stock appreciation right plan, member appreciation right plan, with a limit of, say, 5 years vesting, cliff vesting, we can begin to help those key people on the other side and or family members in setting aside dollars that, one, will keep them affiliated with our company, and or two, helping them build some equity. If they can build some equity and have enough money down, it is possible that they'll be able to get some bank financing and take the risk off of me as well. So again, really important to do that, but we need time. Back in the non-family member purchase structure, going to the outside, if you want, we want to get the best price for our business. And we've seen this over and over again. We do a lot of merger and acquisition work. Let me give you another tip of something that could be very, very, very helpful in the voluntary transition to an outside third party. When people, in many cases, not all, in many cases, when people are coming in to buy our business, it's important to them that key management stays in place. If key management is leaving, the value of that business goes way down. So what we've encouraged and in many times structured is a stay bonus that's provided by the seller, me, to those key people. If they stay for X amount of time with the new firm, I will pay them some money. That becomes a tax deduction to me, taxable income to them. It is unrelated to the new owner whatsoever, but I will pretty much guarantee to new owners that management will stay in place for 2 to 3 years or more. When you do that, you're going to get a premium price for your business. Again, just another tool that could be creatively added in voluntary transfers of business. So the voluntary comes as 1, with time to retire; 2, we've had enough; 3, the marketplace is opportune. But all of the things that I just spoke to you become critically important in making that voluntary transition. Many voluntary transitions don't work for a lack of planning. We'll leave it there for the moment. What I want to move over to now for a little while is involuntary, because in the absence of exit planning, we are leaving our business and it's involuntary. Involuntary could come as a result of business failure. Involuntary comes as a result of death. Involuntary comes as a result of loss of capacity to run the business. In all of those 3, if we don't plan for our involuntary exits properly, many times the only option that's available for a business is its legal dissolution and whatever assets are left distributed to creditors, and we are done. You know, it's like the birth of the corporation or the birth of the company to the death of the company. The death of the company sometimes dies with the owner. So we want to talk a little bit about the avoidance of those kinds of problems and how they should be dealt with when we talk about exit planning and exit strategies. I think a very important component to understand, and we've seen this so many times, it kind of blends back in to our prior discussions about estate planning a little bit and blends back in a little bit to asset protection. And that is what happens in the event of a legal incapacity of us, where we are the star in the business. I think it's critically important that we have thought that out, and we have a surrogate, a successor attorney, in fact, a successor trustee, someone who we trust, has integrity, and has competence to take over the business. If we don't, we're going to wind up with a conservatorship of the estate. We're going to wind up with receiverships in the business. We're going to wind up with litigation. We're going to wind up with problems with banks. We're going to wind up with problems with taxes. The problems just go on and on and on because of the loss of capacity. So I think very important is to make sure that our powers of attorney are appropriately designed and appropriately crafted for the incapacity of ourselves or our key people in the business. So you got a couple of factors that are involved with that. Many people will leave the power of attorney to the surviving spouse if they have one, or even to the children who are heavily involved in the business because they know the best to do, but it's an inherent conflict of interest. When usually the surviving spouse knows nothing about the business, and two, the children themselves are in a conflict with ourselves when it comes to the business. So sometimes I think it's really important to think about that and engage and have an appropriate second that can step up and step in and run the business during the period of incapacity, and if permanent incapacity, to deal with its transition that we're going to talk about in just a few moments. I think that's important. The other thing too is that there are and is available certain types of insurance that we could buy. It's relatively expensive, that will pay a lump sum of money to the business in the event of an incapacity of a key person to help the business with its liquidity requirements during this period of time. And we're going to talk about, what happens in a few moments when we talk about a control agreement and that particular involuntary type of transfer. And the other one that we're all concerned about is death. And in the event of death, how can that business make it to the next generation? So if we had our plans for 5 years from now to go to key management and or family members in an organized plan, what happened if that short-circuited in the event of death, and how do we make that happen at the same time to keep the business flowing and going and doing? All right, now it's very difficult because businesses, some are corporations, some are LLCs, some are multi-member businesses, some are partnerships, some are sole owner businesses, some are spouse-owned businesses. There's just so many different kinds of businesses. So there's so many different types of control agreements that are involved. There are management buyouts, family buyouts, whatever else may be. So what I want to take us through in the time that we have now, before we get to our question and answer period, is the anatomy of a control agreement and the triggers that are involved in the involuntary transfers of businesses, and how those things can be put together effectively and properly to make sure that the business has a fighting chance to move forward. So I think when we talk about that type of agreement, let me tell you some of the things that we have seen over the years. So first of all, we have to have an agreement. Not some tepid thing that's in an operating agreement or in a shareholders agreement, but a well-crafted agreement that's going to deal with all the various different triggers that a business may face. What are those triggers? The triggers are death, incapacity, bankruptcy and insolvency, and we'll just call it for cause departures, divorce, for cause departures from a business, and how those things are handled. So I think it's important to understand some aspects of that. So the first aspect of that, we'll just pick on death. This is the one that everybody talks about all the time. They're put together by seller agreements. So we have to have a value of the business. And it basically says that, look, in the event of my death, we have X number of people who are willing to take over the business and want to buy it out from my spouse. But they need to have the money. Remember, so we have that all of our installment sales, which leaves my spouse as a creditor for the business, not good to do. So many times those things are insured. And one of the things that I find so interesting is that all of you purchase real estate, purchased homes. These are relatively large purchases, commercial real property, and we use an escrow. What is the escrow for? The escrow or lawyers' offices to make sure that all aspects of the contract are actually carried out before there's a transition. Yet I look at all the buy-sell agreements that are out there, operating agreements, many of them, nothing. We expect surviving spouses and their children to carry out all these complicated agreements at a very serious and unfortunate time. That leads to issues and problems. So one of the things we want to do is make sure that we have an escrow type arrangement, trust type of arrangement, partnership type of arrangement in place, so a independent third party can make sure that there is an appropriate and proper transition of business to the next owners of the business in the event of death. Now, remember, if we do not have a transition to a team to take over in the event of death, family members, key management, then we are selling to outside third parties, which have everything to do with the things that we spoke about earlier. And if we don't have appropriate amount of time and capital to sell to outside third parties, the company will wind up being liquidated, which is we really don't want to have happen. So death is a very important component, and we need to build that into our agreements about what happens if we involuntarily exit as a result of death, who's going to take over, what price, what terms, what liabilities. Those get built in. The next area we just talked about was incapacity. And when we talk about incapacity, should we become incapacitated? Let me give you an example. So one of our clients was a large fast food franchisee in Florida, and there were two partners. And one partner, they've been together for a long time. One partner is now in his mid-60s. The other partner he was about 83 years old and was really having really big problems with dementia. And the 83-year-old's partner's spouse, was a little bit older than him, was also having very serious problems with dementia. And their agreements that they had written years ago didn't cover incapacity whatsoever. So what was unable to happen is they needed refinancing or for remodeling of the businesses, and they were unable to, they wouldn't sign the documents, or didn't have the ability to sign documents. They didn't have the ability to deal with getting, or the franchisor would no longer expand their franchise development area because of the incapacity of the other partner. The entire business was shrinking, and was lost for not making proper provision regarding the incapacity of the owners of the business. So when I talk about incapacity, sometimes many of you get that confused with disability. Many of us have businesses that, hey, if you could sit at home in your chair remote like I'm doing now and talk, you can run your business. It's fine. Business. Incapacity is different. Incapacity is when a court of competent jurisdiction said, Harry, you're not competent to do this. You're not competent to make a decision. Or someone is acting in substituted judgment for me. In other words, my spouse is now making the decisions where it used to be me because she holds power of attorney. So someone's acting under power of attorney, someone's acting under substituted judgment. They're no longer running the business. We need to have a plan to make that effective in a involuntary exit. But then we don't want to get thrown out of the business because we're a car crash and we were a couple of weeks, we were, in a coma and woke up and we lost our business. So we need to build some time frames into that. Maybe it's 6 months, maybe it's a year. The average is about 6 months or so. If I'm incapable of making a decision and running my business for 6 months, and even sometimes in a business, 6 months is a long time, then we have an organized transition of the business in an involuntary exit. And we have predetermined price, we have predetermined terms, we have predetermined security agreements that have been put into place to deal with that particular structure. Price and terms is always interesting too. So we have death as a trigger, we have incapacity as a trigger for our involuntary exit. And, we may have a management buyout where management now sees we're 6 months incapacitated, management now steps up, purchases the business. We have made sure that they had the funding to do it, or at least provide the absolute documents that are necessary for them to do it and to make a successful transition of business. Or we've left people in charge at that point to turn around and sell our business at the highest price to an outside third party who's willing to buy our business. Remember, when the key person is incapacitated, usually we're not getting top value for our business at the time of when we sell it. So I think that's a very important component in exit strategies from our business. And what I want to make sure is that each and every one of us has a game plan that's in place of what happens in the event of death, what happens in the event of incapacity. And believe it or not, sometimes we make an exit in a different way. that we have an outside related liability, a car crash, horrible thing that happened in our rental property, we're sued, a judgment comes against us, and our business, our ownership of the business could be confiscated in order to satisfy that claim. In essence, another involuntary exit. We should make sure that that is unable to happen, which can be done with appropriate and proper asset protection, the way in which we hold the operating aspects of the business. So it started, let me go back just a little bit with the thoughts of, we will all make an exit. Yes, we will. The next one is, what's our business worth? What's a full and fair determination? There are many online services today that have great algorithms that could give us a relatively not certified, but a relatively good price to know what our business is worth in the marketplace, taking into consideration its unique consideration. Then we have to decide whether or not we have any buyers. Buyers, family members, and/or key management, and how we fund that and bring that in on voluntary. We want to make sure our business is legally pristine. We want to make sure that we have all of the incapacity conditions put into place and done. What happens in the event of death is put into place, and that we have an appropriate and properly designed control agreement, preordained for price, terms, interest rates, and all the other things that need to be put in place if we have buyers. And if not, we want to make sure that we have everything ready for the outside third-party buyers. There is no magic in exit planning. There will be an exit. Now, statistically, what have we seen? How many businesses do you think are actually lost as a result of death? Believe it or not, very few. Over the last 50 years, maybe 50 businesses were transitioned as a result of death. And how many businesses were transitioned as a result of incapacity? I would say many more, maybe 200. So sometimes we put all of our emphasis on death, but we really should put our emphasis on incapacity as we all get older and live longer today. And how many businesses are sold as a result to a third party? Almost 80% of them are sold long before the incapacity and death. And how many of those have tried to go to family members and key management? Most of them. How many of them made it? Very few of them, for all the reasons that I articulated earlier. So exit planning requires many steps. The idea of an exit, and then again, not to be redundant, a quality, well-done financial plan with a proper valuation of the business, then all the things that we need to do to particularly make an exit. And then to make an exit in the most tax efficient manner. Last part today, I want to talk a little bit about tax efficient manners. There's a big difference between selling equity and selling assets, depending on what state that you're in. There's a difference in taxation. There are some, through the use of charitable remainder trusts, and other types of vehicles that can be used to help mitigate the tax impact of selling a business beforehand, and many tax mitigation strategies that could be used post-sale, depending upon government ideas and government strategies regarding the future taxation of businesses that are being sold. So I think that as part of the planning is also the tax mitigation aspects of what's going on with the business. And I think you all know this, but I'll leave it at this point. Then we'll take some questions and answers. What we see is that businesses that are structured or taxed as C corporations, I've seen, sadly, too many letters of intent, indications of interest, never making it to binding contracts, by the way, of purchasing the assets from a C corporation. They don't want to buy the company, they want to buy the assets. It's a C corp. Ladies and gentlemen, you'll find that most of the time that's the taxation of that is untenable. There's a tax both to the corporation in many cases and a tax upon distribution, very, very high tax rate, which pretty much makes that go off the table. If we have enough runway We have 5 years, as we should have, in planning for an exit. We can make sure that there's one level of tax and not two levels of tax. So what I'm basically saying here is that exit planning is really exit planning. Succession planning really requires some time, effort, and some thought, and a partnership with yourself and a professional exit strategist, and it could be a successful transition. So with that, Paul, that's about as far as we can go today on that strategies. If we can have some questions and answers, I'll be more than happy to take some. Or if not, I look forward to speaking to everybody on another subject matter real soon.
Yeah, got a few questions that were emailed in ahead of time with, from people, and then also everyone that's here, please feel free to put your questions if you have any in the Q&A. So Harry, someone asked about if there are two owners of the business instead of one. Are there some highlights on how that changes the dynamic of how you plan for the exit?
Well, yeah, the dynamic is usually the purchaser of the business from an incapacitated or a deceased owner. If we have another owner, is the other owner, and that's handled properly in an appropriate buy, sell, as we like to call it, control agreement. The control agreement can also be utilized to, if a person wants to voluntarily leave the business, how the price and the terms work out between the two. So at least in this particular case, you have a buyer, you have a price, and it works out very well. We've seen in many occasions that they can't agree, so that would force the business to be sold to an outside third party.
Okay, all right. And then on the liquidity event itself, selling a business, there's a liquidity event. Do you get into ways on how to invest those proceeds for tax mitigation purposes and financial plans?
Yeah. So it's after the event occurs. Those are post-sale tax mitigation strategies. There are some pre-sale tax mitigation strategies. One of them I mentioned in my talk is selling some of our interest, if it's a C corporation or something that's available through a charitable remainder unit trust, which can help defer out significantly the capital gains tax. And depending upon the state of residence, there are certain types of trusts that can help mitigate state income taxation on the gain, especially if the state has a large tax, such as California. Post-sale tax mitigation can be used. One of the tools that we use is a grantor charitable lead annuity trust, reinvestment of proceeds, of capital proceeds into qualified economic opportunity zones, certain types of energy-related investments, and certain type of charitable deductions that can be put together. Not one, but a combination of all of them together can turn around and help mitigate the tax impact of the sale. And the other thing too is that if we have an installment sale, which happens many times between partners or between management buyout or between family members, that taxation is spread out over the years of the installment sale if structured properly.
Okay, and last question I have here is on the buy-sell agreements you see. I know I've heard you talk about this before, but those are not cookie-cutter agreements. There's asset protection provisions built into them. I mean, they're highly kind of efficient documents. Is that
well? They're also highly complex documents. An appropriate buy-sell agreement, I like to call it a control agreement, is a highly complex document that deals with the transition of a business in the event of a divorce, in the event of a death, in the event of an incapacity, and in the event of a bankruptcy or an insolvency, in the event of one of the owners of the company behaving badly, bringing disparagement to the company, preventing company owners from selling their stock or securing their stock against loans that they take by third-party businesses, how prices are determined, how prices are paid, how prices in what jurisdiction, and how disputes are arbitrated are all covered under those types of agreements that every business, when there's multiple owners, should have. But the other thing too is a lot of people don't also recognize that we can set up management buyout agreements where ownership is going to be bought out by clearly indicated management in the event of any of those triggers. A little bit more complex, but it's nice to know that we have a marketplace for our business. And one of the other exits that I did fail to mention what we're talking about in the right circumstances is an employee stock ownership plan. An ESOP is another way, rather than selling to a third party, where we create our own market and the employees can purchase the business themselves.
Okay, great information. Harry, as always, fantastic. Thank you everybody for being here. Again, look for the recorded video. I'll send that out in a few, give us a day or two to get that going. Harry, thanks for your time. Appreciate
Well, thanks.
it.
It's great to be here this morning. Thank you everybody for joining me. And it was nice being a series of 3 with all the YPO members. Thank you and goodbye.
All right.